prosecutors are present as well. Before we bring the jury in, just a couple of housekeeping matters. The first is that I realize that I skipped number 8 in terms of the juror questions. And so just so that the record is clear, that's not an indication that that question is lost or that question form is lost. I just skipped a number in numbering the question forms. I went from 7 to 9. So there's a motion filed by the media petitioners, and I don't know whether the parties have received it or not, but it is requesting access to all non-graphic image exhibits that have been admitted into evidence and displayed in open court whose contents are not visible to the public outside courtroom 201. And as far as I can tell, it refers to the diagrams that have been admitted, which are not visible on the camera, on the closed-circuit TV camera. So I think it's a fair request, but I wanted to run it by counsel first. What I would be inclined to do is to simply scan those and provide them to the media through our public relations representative, Mr. McCollum. But I wanted to run it by the parties first to see if the parties had any position on that. I don't know whether you've had a chance to review the motion yet or not. Mr. Orman, do the people have a position on that? Yes. Okay. Does the defense have any position on that? Yes. And for the record, it's exhibits 1129, 1145, 1147, 1154, 1167, and 1168. And they're all diagrams. Is that correct, Ms. Gerlings? Yeah, I think they're all diagrams. If they're not, I'll let you folks know. But if they are, I don't have any concerns about providing them, scanned copies of them to the media petitioners. Mr. King?
I've just had a chance to very briefly read the pleading, and I thought it was wider in scope than what the court is driving. So, should we have until tomorrow morning to really read it and take a position?
That's fine. And to the extent that it's wider in scope than that, I'm not inclined to provide anything beyond that. I think it's fair to ask for exhibits that have been admitted that are not clearly visible on camera. But I think beyond that, for example, to the extent that it seeks exhibits that were used in opening statements, those are not admitted yet, and I am not inclined to provide those.
And that was where my question came from, because it appeared in the photographs that were attached that it was the opening statement exhibits that were being shown. It was during Mr. Brockler's opening statement, if I recall correctly, and there were some of his PowerPoint slides that you could see on the screen, but you couldn't read them.
That may be, but the motion itself, the title is, it's a motion for access to non-graphic image exhibits that have been admitted into evidence and displayed in open court. So if that's the request, I think it's a fair request, and I don't have any concerns over it. But if you still want until tomorrow morning to think about it, I will allow that.
Yes, please.
Okay, that request is granted. Just a couple of other things. I know that there have been quite a few objections to questions related to injuries. I have overruled most of them because I think that the extent, character, and nature of the injuries is relevant. I think that's probative of the injuries that were suffered by the named victims, allegedly suffered by the named victims as a result of the shooting that took place. And so I think that the people are entitled to present evidence of the character, the nature, and the extent of the injuries suffered. That includes if someone had to have surgery. That includes if somebody needed to have a recovery period. Of course, it has to be within reason. I mean, it can't go too far beyond that, and I think I've been pretty good about making sure that it doesn't go beyond that, and I don't think that the people have attempted to go too far beyond that. I think they've introduced evidence in terms of wounds and injuries and surgeries and medical treatment that was necessary as a result of those injuries, and so that's why I have overruled those objections. When Mr. Nolan was testifying, there was an objection during one of the juror questions by Mr. King related to an inference that he drew from his observations. And the witness had made that statement, I think in response to the previous question from the jury. There was no objection at that point, but then there was an objection when he mentioned it again the second time, again in response to questions from the jury. And at that point, all I said was, well, the witness has answered the question. Let me now clarify the record. I think it is a reasonable inference for an observer to draw, given all the circumstances present and given all the circumstances that he testified about. I think it's reasonable for him to make that inference. I think it may well be the most reasonable inference for somebody to make, given what he said. And given the observations he made, which he testified about, and in addition demonstrated here in court, we're talking about someone who observed that an individual came into a dark theater, and he testified that the individual was shooting people who were sitting in the theater while in the dark, and that he himself was hit during the shooting a couple of times. And he was able to see the shooter at one point, and what he observed was that the shooter had what appeared to be a rifle in his hands, and that he appeared to be looking for more victims. And then he demonstrated what he meant by that. He demonstrated what observations he made. I think that given all the circumstances and observations, that's a reasonable inference. And so I don't need to take any further action in terms of the testimony because he answered the question anyway, and I didn't rule one way or another on the objection. But I wanted to make that record clear. At the bench, I did agree with Mr. King that part of the second question from the jury with respect to that witness should be modified. And I think that question included something like whether the witness thought that the defendant was trying to maximize the number of victims. And there was something about the word maximize, or the term maximize the number of victims that bothered me. And so I modified the question. I took that part of the question out. And I think there's a difference between allowing somebody to say whether the shooter was trying to maximize the number of victims versus allowing somebody to say whether he thought, based on his observations, that the shooter was trying to find more victims. And so I think the latter is fine. The former, I think an argument can be made that calls for speculation, and so that's why I ended up modifying the question. So I wanted to explain that to you, okay? All right, are you ready for the jury, Ms. Nelson?
Your Honor, I do have two brief matters to...
Yes.
And the first pertains to the first record that the court made with respect to testimony of victims about the nature and extent of their injuries and subsequent medical treatment. And before over the lunch hour, the defense reached the conclusion that we feel it's necessary to make a formal oral motion in limine to exclude testimony about subsequent medical procedures and care that the victims have received. Detailed and lengthy testimony about the nature and extent of their injuries. We understand that brief testimony about the may be relevant to the attempted murder counts. Serious bodily injury, as the court knows, is not an element of attempted murder. Descriptions of their subsequent medical treatment and so forth is therefore not relevant to the charges in this case and is not relevant to any stage issue at any stage of these proceedings. Any minor probative, our position is that any minor probative value that this evidence may have is outweighed by the danger of unfair prejudice or anything about these. Or 3, as well as Mr. Holmes' right under the 5th, 6th, 8th, and 14th Amendments to the United States. Find any authority over the lunch hour from Colorado in support of this argument. However, I think distinction between the nature of the injuries, ongoing treatment, and condition of present condition of victim. State versus Hatch at 425 Northwest 2nd, 27, and the pin site, the portion of the case in which this is pages 30 to 32, and that's a
Okay, thank you. I haven't read that case yet. Do the people want to respond?
Yes, Your Honor. Your Honor, first of all, the prosecution would contest that it's not an issue, that we still have to prove that there are 140 counts of attempted murder in this case. There's no stipulation in place. We are still responsible for proving each and every element of this case beyond a reasonable doubt to this jury, which we spent extensive time for 3 months explaining to all of these jurors during individual voir dire. Additionally, Your Honor, the people do have authority for the court. People v. Medina, which is 51 P. 3rd 1006, Colorado appellate case from 2001, which basically says not only are, descriptions of injuries admissible in cases like this, but also photographs of those injuries. Further, Hinton, and that's Hinton v. People, which is 458 P. 2nd 611, and that's a Colorado Supreme Court case from 1969. And also Martinez v. People, 235 P. 2nd 810, which is a Colorado Supreme Court case from 1951. And I also have additional authority from some federal district court cases, Alabama and North Carolina, which the court probably doesn't want at this time, but I have that as well if the court would be interested.
Sure, why don't you give them to me?
Thank you. It's James v. Culliver, that's Culliver. That's a 2014 United States District Court case from the United States District of North Dakota, the Northern District of Alabama, 2014. And then Scrogan, which is Scroggin v. State, which is 529 South 2nd, 1025, which is an Alabama criminal appellate court case from 1988. And then also State v. Siriana, which is Syriani, 428 Southeast 2nd, 118, which is a North Carolina case from 1993. And I have an outline of those cases if the court would like a copy. Thank you, Your Honor.
What's the site for the James case?
I have a Lexis citation, Your Honor, for that, which is 139696, since it's such a recent case. And I can provide the court with a Westlaw site tomorrow, Your Honor, on that, or perhaps on a break.
Okay, thank you.
Thank you, Your Honor.
Hold on just a second. It sounds to me like there is no disagreement that evidence related to the nature, the character, and extent of the injuries is admissible. And the only question is how far that goes. The defense, I think, is arguing that some testimony related to that brief testimony is admissible, but if you go too far, then the prejudicial effect of that evidence can outweigh the probative value. I have been making rulings based on the understanding that the probative value of the evidence was not substantially outweighed by the danger of unfair prejudice. And so what Ms. Nelson specifically was arguing is that evidence related to current condition and things to that effect, whether some was a current, what else did you say in addition to current condition?
Subsequent medical treatment as well, Your Honor.
Subsequent medical treatment, those two items, that goes too far or goes beyond what is allowed by law.
And Your Honor, I would say that the defendant is alleged to be the proximate cause of all of those injuries. There's no intervening causes whatsoever. And I frankly think it's offensive that if people are paralyzed as a result of their injuries, that they need constant daily care up until this point. And I think that the people should be able to discuss the extent of those injuries to the jury. This is a case where we've charged extreme indifference, attempted murder, and I think there were many instances because of subsequent surgeries where those victims were still in danger of dying. And I think it's appropriate. And, if those were the facts with just one attempted murder victim, certainly the court would permit, that evidence. And, I think the people will try to be reasonable and prudent regarding the evidence we present. But it's what the court said. When you have a crime of this magnitude, there's going to be information that's prejudicial to the defendant's case, but it's not unfairly prejudicial.
And many of the counts are attempted murder after deliberation and with intent. In other words, that the defendant attempted to commit the crime of first-degree murder after deliberation and with intent to cause the death of another person. That's what that crime alleges, and that crime is charged with respect to numerous victims in this case. And so, again, I think the extent of the injuries and the nature and character of the injuries doesn't just go to the result of the alleged shooting, but it goes to elements of the offenses charged. And I don't think it's fair to say, well, you can ask the person what they felt that in the moment or what they observed in the moment of the shooting. I think that the extent of the injury encompasses what was necessary in terms of medical intervention to address that injury. I think that goes directly to the extent of the injury. It's one thing to say, well, I looked at my arm and my arm had appeared to have blood on it and blood was coming out of my arm. It's another thing to say, I looked at my arm and it had blood on it, and then I was taken to the hospital and it turned out that I had a broken bone and I had to have surgery. In fact, I had to have 5 surgeries. And they had to insert a rod in there, a plate first, and then after they took out the plate, and then they inserted a rod after that. And even now, I have limited mobility in my arm, or even now, I still have to do physical therapy. That all goes to the extent of the injury, and that's why I have allowed the questions that I have allowed, even if there have been some objections. As Ms. Tisch-McGuire said, though, the people have to be prudent and careful in how they proceed so that they don't go too far. And what the law worries about is that you are presenting evidence to get the jury's sympathy as opposed to for a proper purpose. And that you are, that the evidence, even if that's not your intent, will be so prejudicial that whatever probative value the evidence has will be substantially outweighed by that danger of unfair prejudice. And so far, I haven't seen that with respect to any of the questions that have been asked that I have overruled objections on. But the people have to be careful how they proceed.
Thank you, Your Honor.
All right, Ms. Nelson, you say you had 2 things. What's the second thing?
The second is an oral motion in limine to preclude going forward questions. We've seen this now several times posed to victims concerning their military service and experience and how that relates to their ability to recognize the sounds of gunfire and the types of weapons that were fired in the theater. Your Honor, at this point, it's been established that firearms were fired in the theater that night. Several witnesses have described this in detail, and again, there's no dispute about whether firearms were discharged in the theater or which firearms were discharged in the theater. At this point, the probative value of continuing to ask victims about this is substantially outweighed by the danger of unfair prejudice and is also cumulative. And our concern is that it's improperly bolstering the character and credibility of the witnesses and is an attempt to be ingratiating in some respect to the jury. And again, I would cite Colorado Rule of Evidence 401, 403, Mr. Holmes' rights to due process, his right to a fair trial and reliable sentencing proceeding, as well as the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, Colorado Constitution, Article 2, Sections 16, 20, 23, and 25.
Any response?
I don't know what it means that they're not disputing anything. If they don't want to dispute, they can plead guilty. Otherwise, everything is in dispute, and we've got to plead everything. This thing that they're not disputing everything, I've never heard of a case discussing this. I've never heard of a legal doctrine in jurisprudence that ever I've read since law school that talks about this. We have to prove our case. And we have to prove our case the way we think it is appropriate, not the way the defendant's attorneys think is appropriate. So I don't even know what that means. But, Your Honor, first of all, it's proper lay opinion to talk about the types of gunshots you hear. And the background of a witness is an essential fact for the jury to have in determining credibility. I'm sure the defendant would like it if we put up witnesses and just said, tell us what you saw, where the jury would have no idea what the witness's background is, or what their education is, or what their job is. We've heard objections to what their job is. But I would ask the court to consider the instruction that we give jurors on credibility. What the jurors are supposed to consider on credibility, to consider a witness's knowledge, motive, state of mind, demeanor, manner while on the stand, means of knowledge, ability to observe, and so forth. The background of a witness, what their job is, how old they are, what their education is, where they're from, all of this should go into the juror's determination of credibility. If they're in the military, that is, or formerly in the military, if they're a police officer, formerly a police officer, if they've heard guns go off before and know what it sounds like, that's all something jurors should be able to take into consideration. I do have a few cases that I would like to cite to the court on this point. There's a Colorado case that is not exactly on point, and it's really old, Your Honor. I'm almost embarrassed citing this, but it's what I could find in Colorado. It's from 1903. But we were still the state of Colorado back then. It's not a territorial case. United Oil versus Miller, 73 Pacific, not second or third, Pacific, 627, Court of Appeals, 1903. I would also cite to the court some out-of-state cases. One is McDaniel versus the Commonwealth, 415 Southwest 3rd, 643, and the pinpoint site is 654, and that's from Kentucky, 2013. That's actually about a physician, Your Honor, and in that case, the criminal defendant argued that because the physician was testifying as a lay witness, the prosecution should not have been allowed to ask the physician about his qualifications. And rejecting that argument, the Kentucky Supreme Court said, quote, appellant does not cite any cases holding that a lay witness may not answer questions about his background. Obviously, background information is relevant to jurors in that it aids in assessing the credibility of fact witnesses and determining the weight to give their testimony. Questions within the unique province of the jury. I would also cite to Lamb, like a little lamb, versus York, 247 Northeast 2nd, 197. Pinpoint site is 202 from Indiana in 1969 for a similar holding, Your Honor. So I think that the argument from counsel for the defendant is completely without merit and should be rejected.
All right. Ms. Nelson?
And Your Honor, I would just ask for an opportunity. Obviously, I have not had the chance to review the cases that were just cited by the prosecution. So first, I'd just like an opportunity to review them, and if there's anything I need to respond to, I'd ask for an opportunity to do that in the morning. And secondly, I do think it is relevant that we are not disputing some of these issues when the court conducts its 401, 403 analysis, and whether this evidence is cumulative or whether the probative value is substantially outweighed by its prejudicial effect. I think that's a relevant thing for the court to consider when making the 403, 401 analysis.
I agree. I have to rule now because we have witnesses who are going to testify here in just a moment. And so the motion is denied. I agree with Mr. Orman. The prosecution has the burden of proof in this case. It is the only party with the burden of proof. And even if the defense is willing to stipulate to certain aspects of the charges, the prosecution is not required to accept that offer. The prosecution is entitled to present its case however it wants, as long as it follows the rules of evidence. And there is nothing improper about asking the types of questions that are the subject of the motion in limine. I have allowed brief background questions, very brief, and I've allowed them especially when they go to a reason or an aspect of the story. For example, to explain why someone went to the theater that night, or to explain why someone went with a particular individual to the theater that night. And I don't think there's anything wrong with asking a witness not only to state their name, but to say, what do you do for a living? I do think that that goes to credibility. That doesn't mean that it's bolstering credibility. It's general information about the background of the witness, and the jury is entitled to consider that information in making credibility determinations. I haven't allowed extensive questioning about that. My recollection is that I've allowed a one question type of proposition, one or two, with respect to some witnesses. And with respect to most of those witnesses, the questions have had something to do with the story or something to do with their testimony. In other words, why they ended up at the theater that night, why they ended up going to the theater with the people that they went to the theater with. In terms of military background, I disagree that that's so prejudicial that it substantially outweighs any probative value of the evidence. Number one, to the extent I've allowed it, I believe I've allowed it for the most part because it goes to part of the testimony. Some of the witnesses who have testified have talked about how, as they were making observations during the shooting and they were listening to the sounds, they could tell certain things. Well, the question is, how could you tell that? Why were you thinking that at the time? Why were you experiencing that at the time that the shooting was unfolding? Well, the answer is because I have military background, and in the military I learned the sound of weapons, or I learned the sound of this particular weapon, or I learned about the smell of shotgun or shotgun fire. Those are relevant. They have to be allowed to explain to the jury what they experienced. And in explaining what they experienced, that includes what they saw, what they heard, what they smelled, what actions they took, what actions they didn't take, and why. And the why goes to their background. And to the extent that anyone has testified about military background, I believe that it's been connected to their experience during the shooting, their observations during the shooting. So, but even if someone, just by way of background, says that that's what they do for a living, I don't see that as inadmissible or improper in any way. It's not prejudicial, much less so prejudicial that it substantially outweighs the probative value of the answer, which goes to credibility. So for all those reasons, the motion in limine, the second motion in limine, like the first motion in limine, is denied. I will follow up and read these cases anyway, and if I change my mind, I'll let you know. And then, Ms. Nelson, you can read the cases as well, and if you want to supplement the record at any time, of course, I'll give you an opportunity to do that. All right, let's bring the jury in, please.